All right, good evening, folks. Welcome to Monday Night Law here in Kirk's Law Corner. What is this? July 29th, 2024. Hope everybody's out there enjoying this beautiful weather. We've actually had a little tiny bit of a cool down, but we're going to get back up to hotness. And I've discovered that I just saw it on my broadcasting software that I have to upgrade to X Premium in order to go live on X. Didn't have to do that before, and I can still go live through my phone, but not through my desktop. It's kind of weird how that works. So no longer going to be live on X. Oh, but we can do spaces without premium. So I want to make sure that folks out there on X are aware that I am still live. Oh. All right, get that out there. So, Diesel D, CC, Shabby Maverick, haven't seen you for a little while. Mark Bond, good to see you. Para X-Ray, haven't seen you for a while. Not sure who you are, but I've seen your comments for years now. So thanks for following along. And there's Fix It Fast. Good to see you, brother. And everybody over here on Telegram. Everybody in the Telegram there. Good to see. And just so you're aware, over here on Telegram, I don't take questions on Monday Night Law. If you've got a question, put it in the chat there in the comment section that I've designated for the live, and whether or not I address that question or not, it will be based on the question, whether it has to do with the subject matter of tonight's show, which is form of government and Federalist 51, the different powers, delegations of powers to the different branches of government, separation of powers doctrine, and some of the issues that they ironed out in Federalist 51, which was, they're saying was Hamilton or Madison, but I believe it was actually Madison that did Federalist 51. But I wonder if it was maybe a conjunction, not sure. So, okay, Fix It. Stop with the goofy stuff. Not necessary. Messes up my screen over here. I can't see everybody else's comments. James, good to see you too. Oh, clear back to the Lincoln Room out there in D.C. That was actually what was that? September or October of 2018. Back in the day. Gosh, how time has flown since then, man. Let me tell you. But no fix it fast. What we're actually talking about is the actual separation of powers, not the 19 essential governmental services per the Reconstruction Acts of 1871. No, we're talking about the Constitution and the separation of powers from the Constitution, and what the issues that were being presented before, right? Because see, Federalist was about explaining the Constitution in a kind of breaking it down into more of a layman's terms for the people, so that they would vote to ratify the federal national Constitution. And not only that, what is our form of government? You know, I used to, me personally, I used to call it a constitutional republic. That is false. Our form of government is a Confederate republic. Period. That is it. No other terms, no other verbiage, nothing else, but a Confederate republic. We're not a democracy. We're not a representative republic, a representative democracy. We're not a democracy at all. In no way, shape, or form are we a democracy. We're a Confederate republic. That's what that union means. Union is a league of friendship, a confederacy. So, but yeah, well, you know, Mark here on YouTube, Biden thinks he can change the Supreme Court. Not a chance. Again, the Supreme Court gets its power from where? The Constitution. That's right. They don't get their power from the executive branch, which is kind of what we're going to discuss tonight. But one of the first things I'd like to discuss is the fact that about the U.S. Marshals being out in so-called D.C. So, the fact is many U.S. Marshals have been deployed to D.C. And, you know, I've talked about this for quite a few years now, is the fact that much of D.C. has been worked on being boarded up. They were fencing off, and they were saying, oh, we're just remodeling, we're remodeling. No. This has been ongoing for quite some time. They've been going in and boarding up these buildings and cleaning them out. Sure. Out here in Rumble, huge chimp, Michael. Good to see you, brother. And yes, the founders abhorred a democracy. That's right. Our rights cannot be put to a vote. And it's not my interpretation of a Confederate republic. It's a fact. You know, the thing is right here. Kind of grab this, which if I had more time I'd pull it up, but this Montesquieu's Spirit of Laws talks about different forms of government, and one of them being a Confederate republic. But yet in the Federalist Papers it specifically states a Confederate republic. Now, Mark Bond out here on YouTube, he knows that one off. I have yet to commit some of those to memory, but he cites exactly which ones they are. But in this particular one right here, Federalist 51, we're going to read our Confederacy and our Republic. More state national stuff. If I out here on Facebook, Johnny Frame asking me if I would explain the fraud of state nationals that I spoke of last week. Well, I've done a couple of videos on it, several videos now. The fact is the word national as a status did not come into being till 1878. So how do we reconcile that national is a status that wasn't created until 1878 of our republic? And what body of law do we find national from? And this is, I challenged every single one of them that come at me. I'm an American state national. You are? Where's the law behind that? Oh, well, United States Code. Well, code is Roman civil law. And that was all altered, that fundamental law from common law to Roman civil law, the code, was done by a congressional act in 1873, the Code of Civil Procedure Act. That's the code. Code is Roman civil law. We're supposed to have common law, not code. So the only place you'll find national is from the United States Code and after 1878. So that's the fraud. The real status in America, in this nation called America, per the law of nations, regarded as international law, is citizens, capital C, in their proper person, are members of a civil society who are bound to perform certain duties and subject to its authority. That's Article 6, Clause 3. All the aforementioned senators, representatives, and all of the members of the legislatures of the states and all executive and judicial officers, both state and federal, shall be bound. There it is, members and bound. That's what makes them citizens, civil servants, city servants. Then you have the inhabitants. See, when we go back to Law of Nations, Book 1, Chapter 19, subsection 212 for citizen, Section 213 for inhabitants. And it talks about the inhabitants are foreign too. That's right. That's because they're not bound by the Constitution. And none of the statutes apply to man. Period. That's not what statutes are for. Furthermore, how do we reconcile the fact that all political power is inherent in the people? It doesn't say American state nationals. So, again, proper status in America is citizen, which is a public servant, a member of the legislative, executive, or judicial, whether state or federal, or the people, which, according to Law of Nations, Book 1, Chapter 19, subsection 213, under inhabitants, that there are different kind of citizen. Those are the residents. Okay, so when we declare our status as settling here, that's how we become one of the people. Okay, so that's how that is. Those are the true lawful, and I mean lawful, full of law, statuses here in America, the nation called America. So that's how I expose the fraud of American state national. Furthermore, in the code, when it talks about the definition of a state, right under that same chapter regarding whether you're federal or state, supposed national, when you go to the state part, it says Guam and the Virgin Islands and all that. It doesn't mention anything about any of the United States. So when people say that they're American state nationals, what state are you from? Can't be any of the 50 United States. Uh-oh. So just a little bit of logic and reason totally debunks American state national. Flat out. Just done. Just eats it alive. Okay? Yes, Diesel D's. What a mess these people fell into. It's trickery, right? And see, that's the thing, is it sounds so good, like, oh yeah, you know, you're a 14th Amendment United States citizen, when the 14th Amendment says citizen of the United States. Okay? And was originally, in the intent of it was for the recently freed Negro slaves, because they just supposedly abolished slavery with the 13th Amendment. But, like I've showed the original statutes at large, starting in 1794. In fact, kind of have that right here. I mean, I can just pull that over here and show it to you right now on Avalon. Statute of the United States concerning slavery, 1794, an act to prohibit the carrying on the slave trade from the United States to any foreign place or country. 1800. In addition to the act, this was 1794. And then 1803, an act to prevent the importation of certain persons in certain states whereby the laws thereof their admission is prohibited. And then in the 1807, right? And then in the Constitution, 1808, that Congress can't make any legislation regarding that until 1808. So, the dates of those are far beyond 1871 or 1868. So what are you talking about, abolishing slavery in 1868? No, right here. You know, statutes at large. There it is, right here. So, it's even actually in the draft of the original Virginia Constitution, June 29, 1776. The original draft there was to abolish slavery right from the get-go. So, I don't understand any of this talk about abolishing slavery supposedly in 1868 and then 1964, the Civil Rights Act. This was all just a setup, a scheme, scam, and a fraud to enslave us all. So, how do you pull yourself out of something that's all fraud to begin with? And then you put yourself right back into it, claiming that you're a national. It doesn't make any logical sense. That's the fraud. That's the trickery. That's the scheme, scam, and fraud of Anna von Reitz and everybody else who's picked up on it since. And not only that, furthermore, how do you take a birth certificate, which is fraud from its get-go, you know, pursuant to the statutes at large regarding fraud and Contract Law 101? Real simple. Was there full disclosure? No. Is it mutually beneficial? No. It's an artificial construct. It turns us into a slave. Number 3. Was there a meeting of the minds? No. And they don't have any lawful authority to do that. So that, I mean, right from the get-go, it's unlawful. Void ab initio, from its inception, the day it was enacted, is all unlawful. So how do you take something that's fraudulent, such as a birth certificate, and send it off to a non-Hague Convention nation state and authenticate fraud? You cannot authenticate fraud. I am man, creation of God, born to my father and mother on such and such date and time. That's, per the common law, how it's supposed to be done. We're supposed to publish that in the local newspaper, put it in our family Bible, and be done with it. And then when they come around with the census, that's when you record your newborn son or daughter. That's how it gets recorded. per the supreme law of the land. That's how that's supposed to work. It gets recorded, not registered. So again, more shit made up, more garbage. Okay? Now, let's get back to... Uh-oh. Now what did I do? Okay. So let's get into this Federalist 51 here, because pretty good read. And it, like it says here, this is on avalon.law.yale.edu, one of my favorite places to come for history of law. I mean, clear back to 4000 BCE to 399 to 400, 1399. This is medieval times. This is when you're going to see the Magna Carta of 1215. Okay? So when I say that I've been studying law and the history of law, this is what I'm talking about. Clear back, folks. Long time ago. Come on. Stupid phone. I'm going to turn my sound off so it doesn't go off on this call. But, so, Federalist number 51, the structure of government must furnish the proper checks and balances between the different departments from the New York Packet, Friday, February 8th, 1788. To the people of the state of New York, to what expedient, then, shall we finally resort for maintaining in practice the necessary partition of power among the several departments, as laid down in the Constitution? The only answer that can be given is that as all these exterior provisions are found to be inadequate, the defect must be supplied by so contriving the interior structure of the government as that is its several constituent parts may, by their mutual relations, be the means of keeping each other in their proper places. Without presuming to undertake a full development of this important idea, I will hazard a few general observations which may perhaps place it in a clearer light and enable us to form a more correct judgment of the principles and structure of the government planned by the convention. Now we're talking, again, principles. Laying down the law here, ordained and established, but principles, they're immutable. Just like the plus sign, the minus sign, the multiplication sign, and division sign. Those are principles of mathematics. No man can alter the principles of mathematics. We just don't get to do that. Or it would totally destroy mathematics as a whole if we were able to alter the principles of mathematics. Again, those are the four primary fundamental principles of mathematics that dictate the correct answer every time, regardless of our feelings or opinions. So likewise, in these principles that we're going to be discussing here, they are immutable, unalterable. They are principles. And when we're talking about structure of government, we're talking about form. Okay? So, in order to lay a due foundation for that separate and distinct exercise of the different powers of government, which to a certain extent is admitted on all hands to be essential to the preservation of liberty. Okay. That is the intent of creating government, is to secure these rights. Plain and simple. That is the intent. So, now that we comprehend and then understand, what is the intent of instituting government? To secure these rights, preservation of liberty. But it's life, liberty, and property. But the laws of nature, and nature's God. This is all supposed to be among these unalienable rights, which are supposed to be self-evident. It is evident that each department should have a will of its own, and consequently should be so constituted that the members of each should have as little agency as possible in the appointment of the members of the others. Where this principle rigorously adhered to, it would require that all appointments for the supreme, executive, legislative, and judiciary magistrates should be drawn from the same fountain of authority, the people. Not nationals, but the people. Through channels having no communication whatever with another. Perhaps such a plan of constructing the several departments would be less difficult in practice than it may in contemplation appear. Some difficulties, however, and some additional expense would attend the execution of it. Some deviations, therefore, from the principle must be admitted. No, there's no deviation from a principle. But here they are trying to subvert the laws of their own creation right from the get-go before it was even ratified. In the Constitution of the Judicial Department in particular, it might be inexpedient to insist rigorously on the principle first, because peculiar qualifications being essential in the members, the primary consideration ought to be to select that mode of choice which best secures these qualifications. Secondly, because the permanent tenure by which the appointments are held in that department must soon destroy all sense of dependence on the authority conferring them. It is equally evident that the members of each department should be as little dependent as possible on those of the others for the emoluments annexed to their offices. Now remember, an emolument is any advantage, profit, or gain received due to one's position of employment or holding of office. It's their duties to perform, and it's their pay, and all those other advantages that they get, a stipend attached to some office. Where the executive magistrate or the judges, not independent of the legislature in this particular, their independence is in every other would be merely nominal. But the great security against a gradual concentration of the several powers in the same department consists in giving those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. The provision for defense must in this, as in all other cases, be made commensurate to the danger of attack. Ambition must be made to counteract ambition. The interest of the man must be connected with the constitutional rights of the place. It may be a reflection on human nature that such devices should be necessary to control the abuses of government. But what is government itself but the greatest of all reflections on human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government, which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. But see, again, the government is the people. All political power is inherent in the people. The people create the instrument of government, the Constitution. Of the people, by the people, for the people. That's our republic. That's it. So it has to be done by the people. The whole thing. And that's where we're lacking. The people have been derelict in their duties to perform here due to lack of knowledge, first of all. So, when you say here he says you must first enable the government to control the governed. See, what they try to say there is, well, we govern the people. No. Who's supposed to be governed by the Constitution? They are. The ones that are bound by it. If you're not bound by the Constitution, if you're not a member of the legislative, executive, judicial branch, you're not bound by the Constitution. And then to control those that are bound by the Constitution are governed by statutes, where the Constitution delegates legislative power. And those regulations can only be made by the legislative branch due to separation of powers. The executive branch is not supposed to be creating anything. They're supposed to be executing the laws of its creation that's created by the legislature or the Constitution itself. A dependence on the people is, no doubt, the primary control on the government. So thank you for putting that in there, because that just reiterates exactly what I just said. All political power is inherent in the people. Again, not state nationals. So, but experience has taught mankind the necessity of auxiliary precautions. This policy of supplying, by opposite and rival interests, the defect of better motives, might be traced to the whole system of human affairs, private as well as public. We see it particularly displayed in all the subordinate distributions of power, where the constant aim is to divide and arrange the several offices in such a manner as that each may be a check on the other, that the private interest of every individual may be a sentinel over the public rights. These inventions of prudence cannot be less requisite in the distribution of the supreme powers of the state, but it is not possible to give to each department an equal power of self-defense. In republican government, the legislative authority necessarily predominates. That's right. The remedy for this inconveniency is to divide the legislature into different branches and to render them by different modes of election and different principles of action as little connected with each other as the nature of their common functions and their common dependence on the society will admit. It may even be necessary to guard against dangerous encroachment by still further precautions, as the weight of the legislative authority requires that it should be thus divided. The weakness of the executive may require, on the other hand, that it should be fortified. So, this is kind of where this goes through what we call the gubernatorial veto process, that the executive actually does provide oversight of the legislative. And then so does the judicial. So, where the executive fails to veto a bill that's unlawful and unconstitutional, it can be challenged in the judicial. Now, where we have an issue with the executive, or the judicial. The legislature provides oversight. And then most people are not even aware of this, but the sheriff is supposed to be the bailiff from the executive branch. That sheriff is supposed to be standing there ensuring that the judicial branch does not exceed its authority. And that any other part of what we would consider executive branch, but see, that's the thing, it's supposed to be of the people, by the people, for the people. That this is done through due process of law. That there is a lawful complaint supported by oath laid before the court. That there's an actual injured party who takes the stand, sworn in under oath and testifies and cross-examined by the accused before the judge can make a commitment to jail, issuing a warrant for arrest per the Fourth Amendment. Okay? That's how the executive branch provides oversight of the judicial on the spot. An absolute negative on the legislature appears, at first view, to be the natural defense with which the executive magistrate should be armed. But perhaps it would be neither altogether safe nor alone sufficient. On ordinary occasions it might not be exerted with the requisite firmness. On extraordinary occasions it might be perfidiously abused. May not this defect of an absolute negative be supplied by some qualified connection between this weaker department and the weaker branch of the stronger department, by which the latter may be led to support the constitutional rights of the former, without being too much detached from the rights of its own department? So, let me just finish this. If the principles on which these observations are founded be just, as I persuade myself they are, and they be applied as a criterion to the several state constitutions and to the federal constitution, it would be found that if the latter does not perfectly correspond with them, the former are infinitely less able to bear such a test. So if there's a conflict, which one stands? Well, that's why they said that that's the supreme law of the land, common law of the land. So anything that comes in conflict with the supreme common law of the land is void for any effect. Now, this is where we get into things like, powers of the legislature over the judicial, where the people go through the legislative branch to impeach an elected official and judges, right? That's the process that is due to judges, is the impeachment process to remove their immunity from being sued in their individual capacity. That's due process of law. Our right dictates that no special privileges or immunities shall ever be granted that cannot be altered, revoked, or repealed by the legislature. It's Article 1, Section 2 of the Idaho Constitution's Declaration of Rights. In this point, the right dictates the process. That we have to go to the legislature. Oh, the right dictates this process. The Constitution dictates the sole power of impeachment is in the House, whether state or federal. That's part of our Republican form of government, and which branch of government has what powers, and where it is exercised, and how it's exercised. Okay? So that's a perfect instance where our right and the Constitution both dictate the process. Because again, law of the land literally means due process of law. So the Constitution is nothing but process. The whole thing. It's literally due process of law. It's the process of law. there are moreover two considerations particularly applicable to the federal system of America, which place that system in a very interesting point of view. First, in a single republic, all the power surrendered by the people is submitted to the administration of a single government, and the usurpations are guarded against by a division of the government into distinct and separate departments. Now, that's the thing. No. We, the people, did not give up any of our power. We delegated certain powers, but the people retained all political power. All of it. So, this is the misnomer. And then the part that, per our grand juries, common law, how this is supposed to work, when there's an usurpation of office, we have the power to indict them criminally. We don't need any public servant to have anything to do with our common law grand juries. And again, I hate when they say the power surrendered by the people. No, the power delegated by the people. Because we, the people, cannot delegate a power we do not possess ourselves first. It's a maxim of law. What I cannot do in my person, I cannot do through the agency of another. So logically, reasonably, we cannot delegate a power we do not possess ourselves first. Okay? Surrendered by the people is first divided between two distinct governments, and then the portion allotted to each subdivided among distinct and separate departments. So what they're talking about is basically between state and federal government. Hence, a double security arises to the rights of the people. The different governments will control each other at the same time that each will be controlled by itself. Second, it is of great importance in a republic not only to guard the society against the oppression of its rulers. See, we don't have rulers, we have servants. But to guard one part of the society against the injustice of the other part. Checks and balances. Different interests necessarily exist in different classes of citizens. But see, there again, we don't really have different classes of citizens. You're either an American or you are not. We're all supposed to be free and equal. Joseph Story in his commentaries on the Constitution, under that no title of nobility clause, Article 1, Section 9, Clause 8, talks about that would set up, if we were to allow a titular claim and an odious claim, but set up different classes of citizens. We're all supposed to be equal here. All of us. And then those that are delegated certain powers have to be bound by oath to support the Constitution, because that's a requirement pursuant to Article 6, Clause 3. Every member of the legislative, executive, and judicial branch, whether they're elected or appointed, it does not matter. If you are a member, you shall be bound by oath or affirmation to support this Constitution. There are no ifs, ands, or buts about this. That is the supreme law of the land. We, the people, dictate that you shall be bound to support, not interpret, the Constitution. You do not get to interpret the laws of your own creation. You are bound to support it, not interpret it. Different interests necessarily exist in different classes. If a majority be united by a common interest, the rights of the minority will be insecure. Okay. I love that part right there, because this goes back into, a quote out there or saying out there about what's the difference between a democracy and a republic. And it was attributed supposedly to Benjamin Franklin, but supposedly his response was, well, Democracy is like two wolves and a lamb voting on what to have for dinner. A republic is a well-armed lamb objecting to the vote. That's what's being said right here. If a majority be united by a common interest, the rights of the minority will be insecure. That's a democracy. Putting rights to a vote. No. In our republic, the rights are the law. See, this particular word right comes from the French word droit, meaning right or law. So when we look at rights as law, so change the word from Bill of Rights to a Bill of Law. And again, American Jurisprudence, Volume 16, Constitutional Law, Section 100, 2019 update, talks about bills of rights, plural, and those merely declaratory of the common law. Wait a minute. Rights as the law? Common law? That's right. As a fundamental law, the common law, comes before the Constitution. It gets declared, laying down the law, before the Constitution. To secure those rights, the Constitution is instituted, created by the people. So our rights are actually the law. Everything else, as well as the common law, is part of the Constitution, is part of the common law of the land. So anything that's made by the government is policy. It is not law. Okay? We really need to comprehend that and then understand it. So there are but two methods of providing against this evil. The one, by creating a will in the community independent of the majority, that is, and then what we're talking about here against the evil, is that the minority's rights would be insecure. Well, this is our republic that was created was, hey, our rights are off limits. You don't get to put our rights to a vote. In fact, again, the intent of creating government is to secure these rights. And we're all free and independent of government. You have no authority over our rights. None. No power was ever delegated to alter our rights, to dictate to us what our rights are. No, we tell government what our rights are. Period. And they're bound to support it. And at all times, our rights are to be upheld over any statute. If there's a conflict with the statute and a right, the right always prevails. Constitutional revisions regarding due process of law or any of that stand on a higher plane than statutes and are mandatory. Period. They don't have any authority over that. No delegation of power, no delegation of authority. At all. None. Zero. Alright, so of this evil, the one by creating a will in the community independent of the majority, that is, of the society itself. The other by comprehending in the society so many separate descriptions of citizens as will render an unjust combination of a majority of the whole very improbable, if not impracticable. The first method prevails in all governments possessing an hereditary or self-appointed authority. This, at best, is but a precarious security, because a power independent of the society may as well espouse the unjust view of the major as the rightful interest of the minor party, and may possibly be turned against both parties. The second method will be exemplified in the Federal Republic of the United States, whilst all authority in it will be derived from and dependent on the society. The society itself will be broken into so many parts interests and classes of citizens that the rights of individuals or of the minority will be in little danger from interested combinations of the majority. Now, in a free government, the security for civil rights, so we don't have civil rights. Civil, that's that Roman civil law. Right even from the very beginning here. They kept wanting to call them civil from the Roman civil law. Even American jurisprudence, when I found out about the civil rights section, that's a volume 15, section 2 there, civil rights, I was looking up natural rights. Natural rights and political rights is what we have in our republic. There's no such thing as civil rights. That's Roman civil law, which are privileges that are granted and can be revoked at any time. We're not seeking permission for our rights. So in a free government, the security of natural rights must be the same as that for religious rights, which is natural rights anyways. Liberty of conscience, the right of conscience. It consists in one case in the multiplicity of interests, and in the other in the multiplicity of sex. The degree of security in both cases will depend on the number of interests and sex, and this may be presumed to depend on the extent of country and number of people comprehended under the same government. This view of the subject must particularly recommend a proper federal system to all the sincere and considerate friends of Republican government, since it shows that in exact proportion as the territory of the Union may be formed into more circumscribed confederacies or states, oppressive combinations of a majority will be facilitated. Gia, Confederate Republic. Oh, wait, there's more down here. The best security under the Republican forms for the rights of every class of citizens will be diminished, and consequently, the stability and independence of some member of the government, the only other security must be proportionately increased. Justice is the end of government. It is the end of civil society. It ever has been and ever will be pursued until it be obtained, or until liberty be lost in the pursuit. So, again, it's always been this fight. It's always been this fight for our rights. Magna Carta, the Great Charter of Liberty. 1215, that was it. That was a very crucial point in time in the history of law on the English side, which applies to all English-speaking nations, by the way, as a fundamental law. What they try to say that's an actual constitution, but it's a great charter, corporate charter. Corporations do charters. Common law is constitutions, law of the land, supreme law of the land, common law of the land. So, just as the end of government, the end of civil society has ever been and ever will. In a society under the forms of which the stronger faction can readily unite and oppress the weaker, anarchy may as truly be said to reign as in a state of nature, where the weaker individual is not secured against the violence of the stronger, and as in the latter state, even the stronger individuals are prompted by the uncertainty of their condition to submit to a government which may protect the weak as well as themselves. So, in the former state, will the more powerful factions or parties be gradually induced by a like motive to wish for a government which will protect all parties, the weaker as well as the more powerful. Absolutely. Article 1, Section 9, Clause 8 for the titles of nobility clause. Okay. It can be little doubted that if the state of Rhode Island was separated from what? From what? From the Confederacy and left to itself, the insecurity of rights under the popular form of government within such narrow limits would be displayed by such reiterated oppressions of factious majorities that some power altogether independent of the people would soon be called for by the voice of the very factions whose misrule had proved the necessity of it. In other words, we created a form of government here out of necessity because of the tyranny, of the misrule, of maladministration, of misfeasance and malfeasance, usurpations of power, subversions of law, seditious conspiracies to overthrow the government, the laws of its creation, which leads to treason. In the extended Republic of the United States, and among the great variety of interests, parties, and sects which it embraces, a coalition of a majority of the whole society could seldom take place on any other principles than those of justice and the general good, whilst there being thus less danger to a minor from the will of a major party, there must be less pretext also to provide for the security of the former by introducing into the government a will not dependent on the latter, or in other words, a will independent of the society itself. It is no less certain than it is important, notwithstanding the contrary opinions which have been entertained, that the larger the society, provided it lie within a practical sphere, the more duly capable it will be of self-government. And happily for the Republican cause, the practical sphere may be carried to a very great extent by a judicious modification and mixture of the federal principle. But again, we the people have all the power. We're supposed to be taking care of our form of government. And with the statement that's made there is the larger the society, the more duly capable it will be of self-government. Really? We're well over 300 million people in the United States of America. How hard is it to be self-governed here? So I've come to this recent conclusion. The issue here is two things. One, lack of knowledge. Lack of knowledge of the law itself. Two, fear. Which in my mind, one has to do with the other, because knowledge is power. It literally empowers me. And I've seen it empower other people in all sorts of situations. Not just law. Just in any situation, you know. You get up there to talk about something, people start asking you questions about things you don't know about. You see them stumble and fumble around and all that kind of stuff. But then, in contrast, you look at the people who know their shit, and you start asking them questions about it, and they give answers immediately. Knowledge is power. There is no ifs, ands, or buts. If you have the knowledge, you're empowered. You can answer these questions. You could speak on that particular subject with clarity, with certainty. So, I think fear comes in because of lack of knowledge. Because even the Bible tells us 365 times not to fear. Not to fear man, not to fear this, not to fear that. We're not supposed to be living in fear. It is time for the people to come together and reassemble our Confederate Republic and become self-governed like it was intended and take back our powers. Stop waiting for somebody else to do it. You know, again, quoting Carl Miller, somebody ought to do something about that. Be a somebody. Do something. Learn. Learn due process of law. Learn what your rights are. Absolutely. Warhorse for Liberty over here on Telegram. Be confident in what you know to be the truth. That confidence scares the enemy. Why? Because again, our tongues are sharper than a double-edged sword. When we start speaking law, it literally cuts the enemy down. Well, how are you going to speak the law if you don't know it? That's knowledge is power. They go hand in hand, folks. And so this is the problem. You know, people don't know the law. They can't speak the law. Therefore, they have no power and they live in fear. Karen out here on YouTube trying to teach people about snakes that fear them. Then there's always the element of surprise for both. Right. But think, let's look at primal animal instinct. Primal instinct. Most bears, okay? I've been out in the woods. I've come across bears. Black bears, brown bears, and even a grizzly bear. Now, I know that grizzlies are really more of a, they don't give a shit anyways. But they will still turn and run. Black bears, brown bears, they don't like to be around people. They really don't. You want to talk about scaredy cats, man. I mean, I've seen several videos. I've experienced it myself. As soon as they knew our presence was there, they were getting the hell out of there. Now, unless you come across a mama and her cubs, that's a little bit different story because mama's going to want to protect her cubs. But generally speaking, they will steer clear. Yeah, moose and cougars, yeah. Yeah, we got some of them up here too. Not so much moose, which we still do have some moose here, but right in this particular area, we have mountain lions, cougars. In fact, one of our places that we go camping right there at the turnoff is Cougar Mountain Lodge. Diesel D's here on Telegram. Does Blackstone in his works and the author in this document misuse words like rulers, person, and civil on purpose for the nefarious purpose of subverting the common law with Roman civil law, or are these just innocent typos? I think it's the former. They do not want to put in here and make it very clear who the servants are, and that in our republic we have servants. We don't have rulers. Period. None of them. They serve. Right? Creating the instruments of government that serve them. They serve the people to defend and secure our rights. How can that not be a servant? So, no, they're done on purpose to, to the unsuspecting man or woman out here reading this. Oh, we have rulers, huh? Oh, there are rulers. By reading in here, rulers, and that, oh, well, we have different classes of citizens. We do? I guess, yeah, okay. Well, let's go with two different kinds. Ones that are public servants who get paid to perform certain duties and are bound by the Constitution and bound to support it and bound to perform certain duties, and those that are not. I guess that would be the two different classes of citizens. One being the people, having all political power and having political rights, and capital C citizen in their proper person, governor, lieutenant governor, sheriff, all these capital C proper persons that are created in our form of government by the people, who are the boss, who are the masters. Yeah, I agree about the fear factor out there, and it's ignorance. You know, when fear starts to set in, one, you get adrenaline, right? And once the adrenaline kicks in, then it's like, oh crap. Well, now what? And you start freaking out and you can't think clearly. This is where knowledge is power, because it has helped me change my attitude, remain calm. I get very passionate. I might change my tone of voice, and sometimes even to a point where it's raised quite a bit. But it's an authoritarian voice. I'm not necessarily yelling, but there has been times it's gotten loud enough to consider it a yell when I'm trying to talk over the top of loud noises and other people, like what I did down there at the Idaho Capitol. All the humdrum and crap going on down there, and I raised my voice loud enough, it silenced the whole room. Because I wanted people to listen to the law, what I was speaking, and putting them policy officers in their place. So the thing is having the knowledge has allowed me to stay calm. And then, of course, the part of where I talk about where God has kind of softened my heart a little bit and lowered my level of anger based on the fact that we've all been lied to. We've all been taught wrong. And God teaches us about having compassion for our fellow man. So this is where I'm like, oh man. So I can't get all angry and all that stuff and go off on these guys? No. Because really it's not even their fault either, right? Because they were lied to too. And they're brainwashed and indoctrinated. They go to their little post-academy schools and stuff, and they're taught all this stuff, and they think what that they're taught is the truth. Now, granted, ignorance of the law is no excuse. To know a thing and to be bound to know it or regarding the law as equivalent are two maxims of law. It doesn't change the fact that they've been taught wrong on purpose. Okay? But I can tell you right now, there are more and more sheriffs or potential sheriffs that are candidate elects, like Doug Trouble here in Ada County, Idaho, who ran for office there or was nominated to be appointed, and because the other sheriff resigned. But he's really wanting to learn the actual law, but he's already got a fundamental basis. He already has a basic understanding of our rights. And he knows the system is corrupt, and he wants to fix it. Okay? And there are many other people out there that are like him, that are wanting to run for the office of sheriff, to start taking down the corruption on a local level. Now that's great. We need more people like Doug. Because really, the sheriff is a big deal. Really is. Because the sheriff can deputize as many of the inhabitants to suppress domestic violence. So, this is, a man I've been speaking with and sharing my knowledge with him and talking back and forth. That's the thing is, it's like, I asked him that question and he said, absolutely. If he was sheriff and, shit starts to hit the fan, he's going to the people, the militia, and he will deputize as many of the people or inhabitants as needed. I'm like, right on. Awesome. Because that's what it says right in our own Ada County Sheriff's Office manual. That the sheriff has the power to deputize as many of the inhabitants as needed for the situation. To suppress insurrections and domestic violence. Imagine that. So, things are starting to change, folks. There's a lot more people starting to wake up. And I see it from time to time here, more recently, on my channels here, especially like on the lives. New people coming on and say, hey, first time here, first time listening, first time tuning in. I'm just learning, I'm just waking up. I've seen those kinds of comments in the last year more than I have the entire time that I've been doing lives since September of 2017. And it has become exponential over the last couple years. It's starting to pick up a little bit where more and more people are waking up to truth and starting asking questions and doing their own independent research and not listening to mainstream media. I mean, this is the reason why, in my mind, and my understanding of the military psychological operations to wake the people up to the serious human rights abuse and corruption. Executive Order 13818. So it's not such a big blow to society as a whole that we have a freaking psychological breakdown, the total mental breakdown of society as a whole. Because that, in my mind, is worse. People, turning into little babies and curling up in a fetal position, start sucking on their thumb when shit hits the fan and things start getting real and certain people start getting arrested or shot. I mean, we're at war. Shit like that happens in war. It really does, folks. People shoot at each other. There are shootouts. When you go to arrest somebody, and the evil ones, they don't want to give up. There may be some serious shootouts when it starts getting down to the nitty-gritty here in America. So, we need to be prepared. Absolutely. Greg Danuck out here on Facebook. Absolutely. People are waking up. I am seeing plenty of videos of people presenting themselves in court, winning their cases because of people like you, Kirk, me. Totally awesome feeling. It is. And again, I just reiterate that we just had a case recently. And real simple. Notice of special appearance objecting to personal jurisdiction and the motion to dismiss. We didn't even do the brief this time. And we made it so very short and clear and concise about lack of personal jurisdiction because statutes, per the Rules of Evidence, Title 9, Idaho Code, subsection 303, that all other statutes being public statutes are for what? Creating and affecting corporations. Title 49, Motor Vehicles, subsection 123K, definitions. Motor vehicles, non-commercial vehicles, shall not be required to be registered. And then the big one, if the state is a party to the case, the Supreme Court shall have original jurisdiction, Article 3, Section 2, Clause 2. That's it in the motion to dismiss. That one happened real quick, right after it was filed. That judge stamped on their ex parte communication, basically between the judge and the clerk, no further proceedings. Imagine that. That's a bullshit way of stopping the case when it's a motion for dismissal with prejudice. So, dereliction of duty there, Judge. You're required to grant relief when it is demanded. So, we sent in a proposed order for that judge to sign, and we're demanding that he sign it and grant the relief as demanded in the motion to dismiss. So, I think in that particular case, which is outside of Ada County, which is the predominant case here in Idaho, or predominant area, territory, county, they probably up there, they don't want to deal with anything like that. And, it was quite interesting how fast that judge did that. So we're going to see what happens. With the proposed order. So we're going to get that nailed down, that you're going to sign the order and you're going to do this lawfully, properly. And again, squeaky wheel gets the grease. Now, we've had a couple of other cases, including my own, that they just do not want to dismiss, even though I've had a few cases prior to this that were dismissed. I've also had previous charges in this one particular case. The driving without privileges, the no proof of insurance, the revoked registration and expired registration. The prosecutor never filed any of those, just the resisting and obstructing. So, I mean, how do I show that? How do I show I won that when it never even got filed? There was never even a court case regarding those tickets. You know, somebody, show me you won. I can't even show you that I won because there's nothing to show you because they never even created. I can show you the tickets. And I can guarantee you, you won't find anything because I ended up having to call the clerk of the court and going, hey, I'm supposed to, make an appearance here in this case, and I want to file my notice of special appearance here, and I need a case number for the paperwork. She's like, I don't see anything like that. You got, the citation numbers, and I gave her the citation numbers. She punched them in, and she's like, there's no case. Those were never filed. They don't exist in her system. So, again, automatic win right from the get-go. How many can say that? That they've had a police officer write them traffic tickets. One of them, driving without privilege is supposed to be criminal, misdemeanor, and the prosecutor never filed them. And I want to correct the verbiage out there that's being used about the right to travel. The right to travel is to get on a bus, to get on a plane. That's travel. I'm talking about the right of personal liberty, which consists in the power of locomotion, of changing situations and going from one place to another. That right is personal liberty, not the right to travel. Number 2 is the right of private property, the right to acquire, possess, and utilize my private property how I see fit, uninhibited by any statutes, regulations, ordinances, any of the shit made up by government, because it only affects corporations. It's not for the people. I'm in the private, not the public. Oh, when you leave your house, you're out in the public. No, that's not what that means. In law, in public servant. Okay? That is who that applies to a certain extent. Because we're not supposed to have bills of attainder, bills of pains and penalties. We're also not supposed to have the code, Roman civil law. We're supposed to have common law as our fundamental law. The laws of nature, the law of nations, and the common law as our fundamental law. Not Roman civil law, the code, which doesn't do any of that, doesn't have constitutions. This is why we hear so many times over the years that they don't recognize the Constitution in the courtroom. It's because the code is the law. They don't care about the Constitution because that's a different form of government. That's a different fundamental law. 2 different jurisdictions, 2 different bodies of law. Okay? That's the reason why. Is they're going off of their code. That Code of Civil Procedure Act creates all the courts, including the so-called Supreme Courts. Okay, 1873 in Congress. You have to look it up in your state legislature, legislative acts. But in Idaho, it was 1881. I found it. Section 17 enumerates the Supreme Court, oh my gosh, the Appellate Court, the District Court, and the Magistrate Division of the District Court. All from this act. Wait a minute. I thought the the courts were made by the Constitution, especially the Supreme Court. And then, if we look at the Organic Act for the Territory of Idaho, 1864, that was made by Congress, creating a temporary government, already created the courts, including the common law jurisdiction, is in the Organic Act for the Territory of Idaho. Huh. Okay. Pretty common question out here. Warhorse for Liberty on Telegram here. If you don't have your actual manufacturer certificate of origin for your automobile, doesn't the state technically own your vehicle? If you have time, can you clarify? No. That does not come in conflict with the fundamental law of the laws of nature, of the right to acquire, possess, and utilize my property how I see fit. Why do I need some sort of a manufacturer certificate? Again, possession is 9/10 of the law. This is my property. It's private property. Now, is there a man out there claiming that I stole his property? Has it been reported stolen? If not, then there's no cause of action. Plain and simple. And this where leads into fraud. Private property can only be taken through what? Due process of law, or the law of the land. Where does it say from the law of the land that the state has the authority to convert our private property into commercial property and take it from us? Well, eminent domain. No, eminent. That's not eminent domain. They can take it for use, but they have to give just compensation. And then they own it after they pay us. Yep, absolutely. What are you doing when you register? You're registering it for commercial use. That is what registration is. You're registering it for commercial use. Because that's the only power that they have to regulate is commerce, traffic. Look, folks. I happen to look up the word just and justice. But let's look at what traffic is. Transportation of merchandise for the purpose of trade, in the wider sense of trade, commerce. Interchange of goods, merchandise, or property. Wow. So, are you actively engaged in commerce? In the exchange of goods, merchandise, or property? I mean, it's right in there. If everybody were just to read it, again, I know it takes time. Title 49, motor vehicles. Wow, I wonder where that subject's delegated in the Constitution for the legislature to make. Oh, that's not a proper jurisdiction. They don't have subject matter jurisdiction over motor vehicles. Definitions. I always want to start there. Now, here's an argument that I have, is the fact that Okay. You have motor vehicle as the title. Unity of subject and title here. From the Constitution, Idaho Constitution says unity of subject and title. The subject here, supposedly subject matter jurisdiction, is motor vehicle. All right. Motorbike, motorcycle, motor carrier, motor driven cycle, motor home, motorized motor vehicle. Oh, see vehicle, section 49.123. No. You have to define what a motor vehicle is. Therefore, void for vagueness doctrine here. If motor vehicle is not defined, right here, not anywhere else, but right here, the whole thing is void. It's called void for vagueness doctrine. But, for all intents and purposes, let's go over here to 49-123, because this is section K of 123, is where we find that non-commercial vehicle shall not be required to be registered. Now, let's go here, and we'll go down to vehicle means general. Every device in, upon, or by which any person, corporation, or property is or may be transported or drawn upon a highway, excepting devices used exclusively upon stationary rails and tracks. Okay? What do you mean? Device. What's a device? Assembled vehicle or vessel. Well, vessel has to do with water. But then they go, oh, commercial vehicle or commercial motor vehicle. For the purpose of Chapter 3 and 9 of this title, driver's licenses and vehicle equipment, a motor vehicle or combination of motor vehicles designed or used to transport passengers or property if the motor vehicle has a manufacturer's gross combination weight rating in excess of 26,000 pounds, inclusive of a towed unit with a manufacturer's gross vehicle rating of more than 10,000 pounds. Okay. So I want people to go out, look at your car. There's a little metal plate there. Usually on the driver's side, the left-hand side of your non-commercial vehicle or automobile, or just say vehicle, right? There's a metal plate in there. It'll give you those weights, that GVWR. Most everybody's is under 10,000 pounds. Period. It just is. Now, unless you get into like Ford Excursions and some of the bigger trucks, they're a little bit heavier. But they're most certainly less than 26. Has a manufacturer's gross vehicle weight rating in excess of 26,000 pounds, or is designed to transport 16 or more people, including the what? The driver, or is of any size and is used in the transportation of materials found to be hazardous for the purposes of the Hazardous Material Transportation Act, and which require the motor vehicle to be placarded under the hazardous materials regulations. Now, for those that don't quite understand what that is those are them little placards on the side of like the oil tankers, gasoline haulers there. Flammable, the big triangle, and all that kind of stuff, or corrosive, acidic, those kinds of things. Those are the placards, okay? Now, for the purpose of Title 4, Title 20, or Chapter 4, Title 49 Auto Code, motor vehicle registration and vehicle or combination of vehicles of a type used or maintained for the transportation of persons for hire, compensation or profit, or the transportation of property for the owner of the vehicle or for hire, compensation or profit, and shall include fixed load, specially constructed vehicles exceeding the limits imposed by Chapter 10 of Title 49 out of Code, and including drilling rigs, construction, drilling and wrecker cranes, log jammers, log loaders, and similar vehicles which are normally operated in an overweight or oversized condition or both, but shall not include those vehicles registered pursuant to sections 49-402 and 4902A Idaho Code, or exempted by section 49-426 Idaho Code. A motor vehicle used in the ride-sharing arrangement that has seating capacity for not more than 15 persons, including the driver, shall not be a commercial vehicle under the provisions of this title relating to equipment requirements, rules of the road, or registration. It doesn't apply. Now, I could care less about any of these other farm vehicles or foreign vehicle, because the subject matter jurisdiction here is motor vehicle. All of this shit doesn't belong here because there's no subject matter jurisdiction. Only motor vehicle. Then they say, oh, motor vehicle. Under vehicle, every vehicle that is self-propelled and for the purpose of titling, purposes of titling and registration, meets federal motor vehicle safety standards defined in Idaho Code. Motor vehicle does not include vehicles moved slowly by human power, electric personal assisted mobility device, personal mobility device, electric or motorized wheelchairs, or other such vehicles that are specifically exempt from titling or registration requirements under Title 49 Idaho Code. Okay, remember, we're still under Title 49. Non-commercial vehicle. For the purpose of Chapter 4, Title 49 Idaho Code, motor vehicle registration, a non-commercial vehicle shall not include those vehicles required to be registered under sections 49, 402, and 4208 Idaho Code, and means all other vehicles or combination vehicles which are not commercial vehicles. And then we'll stop right there because they don't have any subject matter jurisdiction over farm vehicles or motorhomes. Only motor vehicles, which are commercial, for hire, that exceed 10,000 pounds, and anything over 26,000 pounds. So, now that we know, the more you know. Right, James? That's always one of mine. Motor is electric motor. These all have internal combustion engines called ICE, internal combustion engine. Motors are electric. Not many people know that. So now, before we got these, electric cars out here, there's no such thing as a motor vehicle. An engine runs on black gold. Yeah, you might as well call it that. Petroleum. Petroleum-based. Black gold. Absolutely. But, this is their own verbiage in here. Vehicle or combination of vehicles of a type used or maintained for the transportation of persons for hire. compensation or profit, or the transportation of property for the owner of the vehicle or for hire, compensation or profit. And right, it just plain and simple. Now, for those over here on Telegram, have you enjoyed the lack of scumbag scammers and spammers? Well, I changed the channel over to private instead of public, just to see what happens. And you know what? I changed it the other day, and not even one impersonator, a scumbag scammer, or even one spam post. Not even one. No comments. Now, the drawback is nobody can do a search and find it. Number two, it changes the link to the Telegram channel. So I'm going to have to get with Miles and submit the new link to my Telegram channel. And the only way to get into that Telegram channel is through that link. So, I've been a lot happier because now I'm not even having to pay attention to Telegram looking for scumbag scammers or spammers. Now, but want to remind people on my Telegram channel, I predominantly do not allow people to share links, especially to other people's Telegram channels, because I don't want people linking to somebody else's spam, scammers, and fraudsters. Number two, I don't want to have to go look at each one that you post out there. Okay? People want to follow them, they can go follow them, but not on my channel. Links to videos and all that other stuff, I predominantly don't allow. Sometimes I will look at them if they're directly related to the post that the comment was made on. I'll allow it. So that's why you'll see sometimes I will leave certain people's comments with links to videos on YouTube or whatever on there. But any that like do self-promotion or trying to promote somebody else, not allowed on my channels. So, with that being said, I hope you're enjoying the Telegram channel. Apologize to those out there that can't seem to find it on Telegram and join, but we will get that link put out there shortly. Alright? So, other than that, I want to direct people to my website, kirkslawcorner.com. So this link right here in the upper left-hand corner to Telegram will not work no more, but all the rest of them do. And again, the P there, that's for Patreon. And for those that would like to help support, I would greatly appreciate you going digitally. This is about it that I've got for digital support right now, is through Patreon. Tier 1, Tier 2, $5 or $10 a month. You know, the price of a cup of coffee a month. One cup. Buy me a cup of coffee. I know there's that one out there. But it's just the same thing. Okay? So, with that being said, that's what I have set up over there basically for donations to support what I'm doing right here, right now, for free. Okay? I'm also live on YouTube and Rumble, and weird that X decided to change their terms of use, basically, their policy, that you got to have a premium account in order to go live on. But tier 3 on Patreon is where you get access to Wednesday night workshop. Okay, again, that's where I'm going over things in more detail, sharing documents, my own personal documents, that kind of stuff. Hey, that sounds like a good one. Right? That's it right there. Going back to school to correct our education. We have to unlearn what we were brainwashed and indoctrinated to believe and relearn the truth, which is what I teach. I show the letter of the law, facts of law. These are not my opinions. These are facts, as it is written. And that is one of the major differences between me and everybody else out there. I actually show the letter of the law to back up what I'm saying. Again, when people try to argue with me or fight with me, they lose every time because the letter of the law prevails as it is written. It's not my opinion. So this is where we do the test whether you're of sound mind or you are insane. Because when the law says one thing, that's 2 + 2 = 4. If you try to come at me and tell me, well, no, 2 + 2 doesn't equal 4 because of this, no, you're wrong. You're not of sound mind. You do not possess logic and reason. And you clearly can't come to a reasonable conclusion based in reality, then you are insane. That's the two choices. Again, the library tab. First, tier 4. Those are for one-on-ones. I see people out here making comments about people needing help and can you do this? Send them over there. Tier 4. People want one-on-one. They want my time. They want my help. That's the way I'm doing it. Okay? That's how you get a hold of me. That's how you get my attention. That's how you get my time. If you want help from me, that's where that's done. Tier 4. Okay? Make sure you read on Patreon the post regarding that stuff, the breakdown of the tiers, to go to Calendly to set up the one-on-ones. All of that stuff is right there. Plus, when you do join, I will send you a private message. And again, I want to remind people that everything regarding Patreon stays with Patreon. It doesn't come over here on Telegram or Facebook or anywhere else. It stays within the program of Patreon. Totally separate from everything else. Okay? Now, library tab. This is where all the good stuff is. Treatise on arrest and false imprisonment. This is reading. Here's that Lex Parliamentaria Americana, elements of the law and practice of the legislative assemblies of the United States of America. Okay? Cannot deny that this is the book of law and practice of our legislative assemblies in the United States of America. That this Mason's Manual legislative procedure references many times, almost on every single page. But this is a subversion of Lex Parliamentaria Americana. We don't need Mason's Manual. We need Lex Parliamentaria Americana. But this is the bar's way of subverting the real law. This is like the code versus the law. Okay? Now, otherwise, forgot on the other types of donations is you can send them over to me, Kirk Pendergrass, at 6477 West Fairview Avenue, Suite G, as in golf, Boise, Idaho 3704. Okay, and shout out to Miles for doing the website. That's click on his name down here if you want to talk with him and consult with him about that kind of stuff. You can. Okay. So any of those regular types of donations, which would be, postal money orders, regular money orders, cashier's checks, regular checks, cash, wrapped aluminum foil, gold and silver coinage, any law books, any of that kind of stuff. Okay, for Calendly, it's not on the website, it's on Patreon itself. It's in the posted posts where I lay all that out. Very, 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 very beginning pinned post. Every time you go on to Patreon, you will see that post first. That's the one that has all the information in there about the tiers, Calendly, the link to Calendly to set up one-on-ones. All of that is all right there in that pinned post on Patreon. Okay? So, other than that, like to put a plug in for the people to reassemble Government de Jure over here, national-assembly.net. Again, national-assembly.net. Every Thursday night, there's a conference call. Right here, the conference call tab. Again, I highly recommend people download and install the free conference call app. It is free. Through the app, whether you're on your smartphones or tablets or you're on a desktop laptop. There's 2 videos here, tutorial videos on YouTube. How to download and install that stuff on your smartphones and what have you, or on your desktop and laptops. Now, here is the link to the free conference call. Now, once you download and install that app on your phones, tablets, or your desktop or laptop, once you click on this once, it will be stored in your app. So you no longer really have to come back here to grab the link. You can just open up free conference call app, join meeting, and go, there we go. Join this one right here. Okay? And that starts at 6 p.m. Pacific, 9 p.m. Eastern, and usually runs for 2 hours. The very first part is the business side of things. The app is freeconferencecall.com. I'm not sure if there is a link here. I don't think there is a link to the app here. Nope. But yeah, you can definitely search for it on your phone. Go to your Play Store or the Apple Store and do a search for free conference call. Download and install that app. Or just go to freeconferencecall.com and download and install it from there instead of through the app. So, but yeah, some business stuff happens first, and I want to try to remind people to keep yourselves muted over there. Unless you're intending to speak, have been called on to speak, or basically raised your hand, but you know, decorum. It's may I, and you have to wait for the moderator to give you the floor in order to speak. So that's how that works. And then the second part is the education, general discussion, Q&A type stuff. So usually we have that, have somebody doing a little bit of education stuff. Sometimes we just have a general discussion. Sometimes there's a topic of discussion that's picked by the moderator or somebody that's running the show over there. And then other times we just, again, have just a general discussion, a general Q&A. And it just flows from there. So sometimes there's really good stuff on there. Sometimes there's good stuff. Sometimes it's, it just depends. Most of the time, generally speaking, it's pretty good. For those that are new, want to get involved, you can go to the forums and blog and go to National Assembly Forums. Click on that and you go down here. Scroll down to the 50 nation states. Find your state. Get in there. Get into the introductions and introduce yourself. Get on the calls. Introduce yourself on the calls. Hey, I'm new here. Just wanted to say hi. I'm from such and such state. Any chance that I can get in contact with a coordinator or moderator from that particular state? Oh, please send an email to contentmanager1, the number 1, at yahoo.com. Okay? We got to get this. We got to reassemble, folks. There is no ifs, ands, or buts about it. There is no other way to do this. This is it. In order for us to be self-governed, in order for the people to take back their power, we have to have the people. Now, again, for those that have done the American state national paperwork, some of it, any of it, all of it, you're excluded from this because you're a foreigner. You're not one of the people. You're a state national under the United States Code. That foreign law. Now, another thing that I would like to point out here, especially for the new people, this resources. What's our current situation? Where are we the people? There's some public notices that have been published. 1638 Fundamental Orders, Assembly supporting videos, important censored videos, and then the 10 steps to an assembly. Here's their handbook. Okay, lap book. I'm not sure what that one is. This is the training manual, the citizenship training manual. This is a military training manual, instructional manual. Okay. So there's that in there. Under the resources tab. And then we got some assembly introduction videos. Or video, I should say. And then, of course, Jason with his Hardline podcast, which I've been on a couple times. I've actually had Jason on with me before. So, good man over there. Has some pretty good stuff over there. But that's through Podbean. The only place you can... Is it going to? No. I guess you have to go. You can go to his website, hishardline.com. Get a little bit more from him, but you'll have to download and install the app the Podbean app. That's that little icon right there. Some pretty good stuff coming out of there from Jason, this man. Good stuff, okay? So, other than that, God bless America, God bless the world, God bless the people, men and women of the earth, okay? I want to thank everybody for being here tonight, and thanks for being here, wanting to learn, your interest, and all that good stuff. We got to reassemble, folks. Put on that full armor of God. Let's be somebody. Let's do this. Okay? God bless. Have a wonderful night, everybody.